in depth. On November 8th, Vermonters will vote on 2 additions to their state constitution. Proposal 2 prohibits all forms of slavery. It passed the legislature unanimously. But Proposal 5 is more controversial. It puts an individual's right to make their own reproductive choices, including abortion, into the document. It would add this sentence to the Vermont Constitution, Article 22, that says, quote, that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course and shall not be denied or infringed unless justified by a compelling state interest achieved by the least restrictive means. There are different views on what that sentence means going forward. Governor Phil Scott says he will vote for it. Catholic Bishop Christopher Coyne is strongly against it. We begin this morning with a physician and OBGYN at the University of Vermont Medical Center on where we are today. Joining us now, Dr. Lauren McAfee, an obstetrician and gynecologist at the University of Vermont Medical Center. Welcome to NBC5 In Depth.
Thank you so much for having me.
Abortion's long been a political issue, but I suspect it's also something that is subject to a lot of misunderstanding. So I wanted to clear up some basic facts about abortion. If a woman comes in to you seeking an abortion, are there any restrictions on that as to when she can end her pregnancy?
So that's a great question and really depends on a number of factors at play. Here in Vermont, we have restrictions enacted, I would say, at the hospital or practice level, but we don't have specific federal or state restrictions that limit our access. Where I work at the University of Vermont Medical Center, we have a robust abortion policy that allows for abortion decisions to remain between a patient and their healthcare provider, and they are able to seek abortion through 21 weeks and 6 days of pregnancy. Abortions after 22 weeks are considered in unusual or extreme circumstances under consultation with our ethics committee and team.
So that's roughly halfway through.
Yep, just about.
Okay. What about the term fetal viability? How is that considered now?
So that relates to the question of whether or not a fetus is able to survive outside of the uterus. That is a bit of a moving target and really depends on the technology and resources available. Generally speaking, we support and allow for resuscitation of fetuses at 22 weeks, though the outcomes aren't great. And so it's up to the parents actually to decide about resuscitation between 22 and 25 weeks. After that point, then viability is assumed. So I would say it's, again, a gray area, as many things in medicine are.
So if a patient comes in seeking an abortion after that point of fetal viability, you will, barring some exceptional circumstance such as, her life, you don't perform that?
That is correct. So in those cases, if a patient is seeking what I would call a non-medically indicated, so not a life-threatening complication of pregnancy or not a severe fetal anomaly, and they're calling to seek services after 22 weeks of gestation, we actually will refer them to clinics outside of the state that would offer those services in closer proximity to their home.
Those who are trying to defeat this constitutional amendment in November point to, they argue that this will enshrine late-term abortion into the Constitution. Does that term even have a definition?
It doesn't, and that's been a big challenge in some of the misinformation that's been swirling. In medicine, when we talk about a late-term pregnancy, we're talking about a pregnancy that's between 41 weeks and 41 weeks and 6 days of gestation. The term late-term abortion has never formally been defined, and so we try more to refer to abortions based on their gestational age, so maybe abortions at or after 18 weeks or 20 weeks or some other arbitrary cutoff. But that creates some of the misinformation and challenges around how we communicate and discuss both with the lay public and with our own patients.
Do you personally have any issues with respect to the wording, the precision in the language in the amendment before voters this November?
I don't. I think the constitutional amendment is designed to support and provide protections for patients and their healthcare providers to make decisions that are best for them without interference from legislators.
What do you think is, you see patients daily who come in seeking abortion care. What do you think is the biggest misconception about this group?
I think a lot of people assume that this is a decision that patients make lightly and just wake up in the morning and say, you know, today I'm just going to seek an abortion. And the reality is that women and patients and their support teams really go through a lot of deliberation and consideration about this decision, regardless of if it's in the first trimester or the second trimester. And they really take into consideration the unique needs and issues that are affecting them, maybe other childcare or other responsibilities that they have. And my role then is to help guide them through their options and resources available and make sure that they understand the risks and benefits that are unique to them, but ultimately lead them to make that decision with the compassion and lack of judgment that they're seeking.
Dr. Lauren McAfee from UVM Medical Center, many thanks for being with us.
Thank you so much for having me.
Coming next, we debate the question. Two state leaders with very different views on Proposal 5 join us in a moment. Back now with the debate. We've heard about the abortion practice in Vermont today, but how much would change, could change, if voters approve the Reproductive Liberty Amendment? Joining us this morning on the left, Lucy LaRiche. She's Vice President, Public Affairs, Planned Parenthood of Northern New England, among her other roles. And on the right, Representative Ann Donahue, Republican of Northfield, and spokesperson for Vermonters for Good Government, which opposes Prop 5 or Article 22. Welcome to NBC5 In Depth.
Thank you. Thanks.
Easy question for each of you. Lucy, why should voters approve this amendment?
Oh, well, Stuart, great question. At a time when politicians in half the states in this country are moving to ban or severely restrict abortion access, Planned Parenthood Northern New England supports Proposal 5, the Reproductive Liberty Amendment, because it will protect the full spectrum of reproductive health care, including abortion and contraception, and will ensure that important personal healthcare decisions remain between patients and doctors, not politicians. Vermonters have had this freedom for the last 50 years. Passing Proposal 5 will ensure the rights we have today won't be gone tomorrow.
And the same question, why should voters say no? What is your principal objection?
Well, Stuart, I think people need to realize that Proposal 5 is a fundamental change to the legal values and standards that were expressed in Roe versus Wade. Article 22 goes way beyond it, goes to the extreme by refusing the balancing of any rights. People believe in upholding Roe as the right standard. You have to look at what that court actually said. First said that though the appellants and some amici argue, and this is a quote, that the woman's right is absolute and she's entitled to terminate her pregnancy at whatever time, in whatever way, for whatever reason she alone chooses. With this, we do not agree.
Okay.
But that's what Prop 5 establishes, a sole right that doesn't include any balancing for the fact that we have a viable third-term baby. And that's contrary to the overwhelming majority view. So we think that would be a vote reflective of Vermonters' views to vote no.
All right. Lucy, I'm sure you have seen these flyers. I've received them. A lot of people I know have received them. They say that Prop 5 or Article 22 would, quote, guarantee abortion right up until the point of birth. That gets everyone's attention. What do you say to that?
Yeah, it gets everyone's attention. It's a scare tactic. It's an extreme assertion, and it's simply not true. Let's look at the facts. Every abortion in Vermont is required to be reported to the Vermont Department of Health for their vital statistics records. The Vermont Department of Health publishes those records. We know that 1% of abortions in Vermont are performed at 21 weeks or later. And those are there are 0 abortions performed in Vermont that are elective abortions. The constitutional amendment would enshrine basically the current policy practice that has been in existence in Vermont for the last 50 years. And that involves allowing healthcare providers and patients to make the best medical decisions for the patient without government interference.
All right. Anne, is this just a scare tactic? This doesn't happen now, we're told.
Well, Stuart, the scare tactic is that Roe v. Wade has anything to do with Vermont's rights, because it actually doesn't. And those 50 years that were referenced, even the most conservative legislatures never passed any restriction. Vermont controls that unless the federal government changes things, in which case our Constitution doesn't change it. But I think what is important is to realize is that elective third trimester abortions are practiced currently outside of Vermont. And it's only because of UVM's internal policies that Vermont women have to leave Vermont to access them. That becomes a constitutional burden if it's an unlimited constitutional right to access. And Prop 5 enables a court to actually find that private entities are unconstitutionally burdening a person's right. So unethical providers could come into the state. Things could change. The fact that nothing is happening today doesn't mean it wouldn't change, particularly once Prop 5, if it passes. And in fact, those elective third trimester abortions that may not happen here today would be constitutionally protected in the future if Prop 5 passes.
Lucy?
Well, I think I just want to get one thing straight. There is the fact that there might be some elective later term abortions that happen later in pregnancy elsewhere in the country seems to be a bit of a red herring here. I'm not really sure I understand why we would be concerned. Well, I think I'm going to back up for a minute because I know that the Guttmacher Institute had published information on abortions that happen later in pregnancy. And of those abortions that happen later in pregnancy, they're not elective. And those reported pregnancies or the abortions were not elective. So I guess I'm just questioning this assertion that there are all these elective abortions that happen later in pregnancy because I have not seen that data.
Let me ask you about the wording of the amendment that says that the individual shall have personal reproductive autonomy unless, presumably, the Supreme Court finds a compelling competing state interest. What might that? What about that balance? I mean, that's not defined, but what could that involve, Anne?
Well, of course, that's putting into the Constitution what's been a judiciary decision on the highest threshold of protection. So by putting it in the Constitution, it actually ties the court's hand in a way that hasn't been done and isn't done for any other constitutional right. But the legislature's already made the determination that there's no state interest at any stage of pregnancy. So it can't become a constitutionally compelling interest. The Solicitor General testified in the legislature that a law that would define a viable fetus as having a life interest would be unconstitutional under Prop 5.
Is that true, Lucy?
So the compelling state interest, the strict scrutiny standard that's correct. It is the highest form of legal scrutiny or legal standard. It does not mean that a future legislature couldn't pass a law that infringed upon one's right and then bring it to the courts to have it out per se. the state still has the ability to make the argument to a court that they have a compelling interest to limit in some way someone's reproductive rights. But by putting that standard in there, we're saying, look, we're taking these rights really seriously in Vermont. And if you feel like you have a compelling interest to infringe on someone's right, state of Vermont, by passing some law that would do that, you would have to tailor the solution. And we agreed, assuming that the courts would agree, you would have to tailor the solution so narrowly as to only address that compelling interest. It's a high bar. It should be a high bar. 80% of Americans agree that abortion should be safe and legal. These are not places where politicians have, I don't believe politicians should have a place in the exam room or in practicing medical care. Politicians are not healthcare providers, and they can never, and they're not people who have walked in the patient's shoes. We need to keep healthcare patient-centered and really dictated through a patient and
understood.
providers.
But let me ask a hypothetical. A woman walks in after this amendment has passed, and she's 8 months pregnant, and she says, you know, I just don't want to be pregnant anymore. It's inconvenient. What will happen if this amendment is in our Constitution? Lucy?
Well, yeah, first of all, I just want to say, I think that is
It's a hypothetical.
a wild hypothetical. I think
Okay.
that doesn't happen. People who get to their eighth month in pregnancy are fully intending to have that, are fully intending to give birth and have that child. There is no healthcare provider in the state of Vermont who would perform a termination at that gestational age, at viability at eight months gestation. So I don't think, so in Vermont, that I guess all I can say is that would not happen.
And
it doesn't happen now, and it wouldn't happen after this amendment passed in Vermont.
So, Stuart, I would agree. There's no current healthcare provider in Vermont. But what we're saying constitutionally is that if there were one in the future, we could not intervene. I think a couple of previous points, the Guttmacher Institute, when we talk about elective, we're making the distinction maybe between social reasons, which were a majority of the reasons, not a minority, versus medically necessary save the health or life of the mother. And you know, in terms of compelling interest, I think the piece that was missed there in saying, yes, of course, the legislature can argue for compelling interest, but there was an opinion directly expressed by the Solicitor General that it would not be considered a compelling interest, that saying that third trimester pregnancy involved a human life, that level would be unconstitutional under Proposal 5. That was a legal opinion that the legislature was informed of by the Solicitor General.
Lucy LaRiche and Ann Donahue, many thanks for sharing your views this morning.
Thank you.
Thanks, Stuart.
We'll take another look at the wording of this amendment with a legal analyst when we return. If Proposal 5, or Article 22, is approved next month, it seems likely to face an eventual court challenge. More on that now with law professor Jared Carter.
Joining us now from South Royalton, Jared Carter. He's a professor and legal analyst at Vermont Law and Graduate School. Welcome.
Great to be here, Stu.
That one sentence seems to say different things to different people. Do you expect if this amendment passes, it's going to be challenged?
Oh, I think it certainly will be challenged. And that's what the courts are for. And in the end, it will be the Vermont Supreme Court with respect to the constitutional provision that has the last word. The language isn't, I think, as convoluted or confusing as some folks are maybe presenting. It's pretty standard language when it comes to looking at fundamental rights and fundamental liberties.
All right, we'll put that line on the screen again. And it talks about a competing state interest that might justify infringement on your, personal reproductive freedom. I mean, but it doesn't define what that competing state interest might be.
Right, exactly. And if you study the holdings of appellate courts like the U.S. Supreme Court and the Vermont Supreme Court, like I do, what you see is that when you're talking about a fundamental right or a fundamental liberty, courts apply what we call strict scrutiny. And they say that the government can only infringe on that right if it has a compelling interest and that the law is narrowly tailored or is the least restrictive means. So I think what we're seeing in this amendment is really parroting what the courts already say about fundamental rights and fundamental liberties. And so it isn't a complete prohibition on state action. It just says, since this is a fundamental right and liberty, the state's got to have a really good answer and good reason before it acts.
So that would be left to the Supreme Court, state Supreme Court.
I think ultimately that will be something that the courts will get involved in interpreting, yes.
Can you imagine what state interest might supersede one's individual liberty?
Well, it's hard to say. Certainly in other contexts, courts have held that certain interests of states do supersede. That often comes up in the context of two competing rights. So certainly courts have said that states have an interest in preventing discrimination, and that even if a law burdens, say, the freedom of speech, a state may apply an anti-discrimination law. So there's certainly instances where there are compelling interests, but it's a really high burden for the state to meet. And I think that's the purpose of this amendment, not to say the state can never act, but that it can only act when it comes to this fundamental right if it has a really good reason, and that's the only way to achieve that outcome.
Would a so-called late-term abortion, for example, without medical, rationale, be such a competing state interest?
Well, I think, again, the courts would look at it and say, at what point does it become a compelling interest? And I think certainly that is one outcome that a court could conclude, that at some point, the state then has a compelling interest. And I think that's in part what the Roe and Casey decisions, which were overturned by Dobbs, that sort of brought all this to the fore, originally said. So in many respects, I think this amendment sort of tracks that logic.
How long might a state Supreme Court challenge ultimately take?
Well,
how far after passage might we get a definitive answer, in other words?
Yeah, I mean, so I think it probably isn't going to happen until after passage. And then you're going to need a plaintiff who's been injured to bring a claim. And I think it's a little bit unclear who that would be, because to get into the courthouse door, you have to show that you've been injured in some way, which makes it a bit circular. But to the extent that this does make its way up through the courts take a long time. And I think it could be months and certainly months and perhaps years before we get a definitive answer to these questions.
Finally, what happens if the Congress of the United States outlaws abortion under federal law in every state, and we have such a provision in our state constitution?
Well, I think the first thing that would happen if Congress did that is that there would immediately be a constitutional challenge to that law in federal court. And I think it's very unclear. And in fact, many folks argue that such a law by Congress would be unconstitutional, because remember, Congress has limited authority, and it's limited by what the Constitution says. And so Congress generally can only pass laws that impact what we call interstate commerce. It's the Commerce Clause in the Constitution. And there's many who say that a ban on abortion simply wouldn't meet that test and would be unconstitutional. But if the US Supreme Court decided that a ban on abortion was constitutional, then I think the supremacy clause of the Constitution would kick in. And that says that a state law or constitution generally cannot overrule or nullify a federal law. So I think our constitutional amendment would be on thin ice.
Jared Carter, many thanks for being with us.
Great to be here, Stu. Take care.
A lot to consider. That's our program this Sunday. We'll continue our Commitment 2022 political coverage here next week.